Hey everyone, good afternoon, morning, or evening, whenever you're viewing this. So, this just was published. I just saw it last night. Charles Hoskinson, the founder of Cardano, came out and did a video bringing to light this law firm, Cooper and Kirk, that published a memo regarding Operation Chokepoint 2.0. It gives us some validation of what we all believe. If we're those of us who are in the crypto space know that, you know, the government, the United States government, and actually countries throughout the world are striving to suppress cryptocurrency, blockchain technology for fear of disrupting their power supremacy. So I want to take a few minutes and go through this with you. I'm just going to give you a kind of the summary of it and my thoughts. Cooper and Kirk is a very high-profile law firm based out of Washington, D.C., and this is just some of their clients that they've worked with: Shell Oil, Microsoft. It just goes on. Governor of Florida. You can just kind of see that this is not just some small law firm. This is a pretty heavy-hitting organization. So before I go into this, so their law firm actually was against Operation Chokepoint 1.0, which, as you may or may not remember, so basically what the Operation Chokepoint series is an kind of a unofficial way or an unofficial attack to suppress, in this case, cryptocurrency and anyone who is involved, exchanges, banks. We saw this with Signature Bank, how they shut Signature down without any sort of legal justification for it. And I want to go through this with you. It's sort of this document, this memo, basically validates what all of us in the crypto space have believed is going on. And honestly, anyone with a brain and a set of eyes can see that, the United States government is really going after cryptocurrency, anyone who involved in the technology, any crypto projects, any exchanges. And I want to go through this, and I'll post a copy to this document, as well as Charles Hoskinson, his video that he did last night that basically covered this. So let's go down, and I'm just going to read kind of the executive summary. I'm not going to go into every point. I think there's like almost 40 pages here. But if you want to take a look at it, you're more than welcome to read at your own leisure. As I said, I'll send a link, or I'll post a link in the description box below. But here, basically, the executive summary. Recent stories in the financial press have uncovered a coordinated campaign by Prudential Bank regulators to drive crypto businesses out of the financial system. Bank regulators have published informal guidance documents that single out cryptocurrency and cryptocurrency customers as a risk to the banking system. That we know that already. That's why they're shutting down any bank that has anything to do with cryptocurrency. Businesses in the cryptocurrency marketplace are losing their bank accounts or their access to the ACH network, and that's actually happening now. I believe Kraken that just happened to. And again, you can control how people can purchase, or what you can do if you take away their ability to purchase crypto using bank accounts, debit cards, Visa cards, all those things. This is all going to be on their hit list, and of course ACH we've already seen. Suddenly, and with no explanation from the bankers, the owners and employees of cryptocurrency firms are even having their personal accounts closed without explanation. And over the past 2 weeks, federal regulators have shut down a solvent bank that was known to be serving the crypto industry, Signature Bank. And although it is required to resolve banks through the least cost resolution to the Deposit Insurance Fund, the FDIC chose to shutter rather than sell the part of the bank that serves digital asset customers. So basically what that's saying is that they shut the bank down, and instead of allowing someone to come in and take over that service, they're closing that. They're taking away the ability for digital assets to be bought, sold, whatever, on that bank. So, which is unprecedented. It's illegal. And this whole document basically outlines in specific detail how illegal what's going on is actually going on with Operation Chokepoint 2.0, costing the fund billions of dollars. The pattern of events is not random, and we have seen it before. This is not the first time the federal bank regulators, working with their state-level counterparts, have abused their supervisory authority to label businesses unworthy of having a bank account and worked in secret to purge disfavored lines of commerce from the financial system. Beginning in 2012, which is Operation Chokepoint 1.0, which this law firm actually took them on and won. So Cooper and Kirk, they are no strangers to this. They were there back in the beginning. So I don't know. Maybe we haven't seen the last of Cooper and Kirk. And let's keep going. Beginning in 2012, the Federal Deposit Insurance Corporation, the Office of the Comptroller of the Currency, and the Board of Governors of the Federal Reserve System carried out a coordinated campaign to weaponize the banks against industries that had fallen out of favor with the administration, including gun stores, pawn shops, tobacco stores, payday lenders, and a host of other brick-and-mortar businesses. That campaign was called Operation Chokepoint. Our firm successfully challenged Operation Chokepoint, and it was brought to a halt. The current bout of regulatory overreach against the crypto industry is illegal for much the same reasons as its predecessor. Operation Chokepoint 2.0 deprives businesses of their constitutional rights to due process in violation of the Fifth Amendment. It is well settled that when a federal agency attaches a derogatory label to an individual or business, and this stigmatizing label causes the business to lose a bank account or broadly precludes them from the pursuit of their chosen trade, the agency has violated the due process clause of the Fifth Amendment, unless it first afforded the individual or business a right to be heard. This is precisely what the federal bank regulators responsible for Operation Chokepoint 2.0 have done and continue to do by labeling crypto businesses a threat to the financial system. Operation Chokepoint 2.0 violates both the non-delegation doctrine and the anti-commandeering doctrine, depriving Americans of key structural constitutional protections against the arbitrary exercise of governmental power. By leveraging their authority over the banks to acquire the power to pick and choose the customers whom the banks may serve, the bank regulators have exceeded their statutory authority. The bank regulators are charged with supervising the safety and soundness of the banks. Their effort to anoint themselves the gatekeepers of the financial system and the ultimate arbiters of American innovation and American economic life cannot be permitted to stand. The federal bank regulators are also refusing to perform their non-discretionary duties when doing so will benefit the cryptocurrency industry. Why would we do that? Why would we help an industry that's trying to circumvent our power? So they say. Anyway, state banks that are statutory entitled to access the Federal Reserve System are being denied their rights solely because they serve the crypto industry. The federal bank regulators are not free to pick and choose which statutory obligations they duties they wish to perform. All right, we have a little bit of a. That's not me, guys. That's a little bit of some typos going on. I would have liked to have seen them tighten it up a little bit, but whatever. Let's keep going. The federal bank regulators are evading the notice and comment rulemaking requirements of the Administrative Procedure Act by imposing binding requirements on the banking industry through informal guidance documents. This is undemocratic since it deprives the public of the right to comment on proposed rules. And it also runs contrary to the principle of judicial review, since courts lack the power to review informal agency actions. Finally, the federal bank regulators are acting in an arbitrary and capricious fashion by failing to adequately explain their decisions, by failing to engage in reasoned decision-making, and by failing to treat like cases alike. It is difficult to imagine a more arbitrary and capricious agency action than simultaneously placing a solvent bank into receivership solely because it provided financial services to the crypto industry, while permitting insolvent institutions not tied to the crypto industry to continue operating. We therefore urge Congress to perform its oversight role and hold these agencies to account. In Section 5 of this paper, we propose a series of questions that need to be answered and a series of steps that Congress should take in an effort to obtain these answers. Yeah, that's going to be, I really hope they do that, but we know how politicians can, spend 20 minutes answering a question without answering it. So I don't know. We'll just have to see. First, Congress should require the bank regulators to produce their communications with supervised financial institutions and state regulatory agencies regarding the denial of or regulation of access to the financial system by crypto businesses and banks that serve the crypto industry. Second, Congress should require the federal bank regulatory agencies to explain the basis for their conclusions that the safety and soundness of the financial system require the insulation of the banks from blockchain technology, from customers who operate in the crypto space, and from state chartered depository institutions that are currently serving those customers. And third, Congress should make clear to the federal bank regulators and all federal agencies that the notice and comment rulemaking requirements of the Administrative Procedure Act are not optimal. Fourth, Congress should investigate the role of federal regulators in the decision by the New York Department of Financial Supervision's decision to shutter Signature Bank. Congress should also determine the FDIC's role in excluding bidders who wish to acquire Signature's digital asset businesses from the bidding process. And fifth, Congress should investigate whether bank regulators are acting to squelch private sector innovation in order to clear the field of competition for the benefit of existing federally regulated banks or for a federal cryptocurrency alternative, CBDCs. The persistent unwillingness of the nation's bank regulators to follow the law and obey the Constitution calls out for congressional action. Cracks are starting to form in the American financial system as its regulators increasingly abuse the power to achieve aims outside their authority and beyond their competence. We are now starting to see high-level organizations come out and publicly outing the regulators for what they're doing with their illegal actions. So what we can do is we can share this document, this memo, with our local congressmen and women, share it with your friends, your family, and this document gives credence to what we've all been saying. It's not a conspiracy theory. This is fact. This is what's happening, and it's got to stop. So I hope you guys are having a great day. As I said before, I will share this in the description, as well as Charles Hoskinson's video last night regarding this memo. And if you like any of the content that I'm providing for you, please feel free, subscribe, hit that notification bell. I really appreciate you all. Have a great day. And remember, here at the Crypto Dojo, crypto never sleeps.